Mr. Craig, and I think we're waiting for Mr. Eaton.
Good afternoon.
Hi, Mr. Craig. There we go. All right, we have everybody here for the Sloan case. Mr. Eaton, do you wish to reserve any of your time?
5 minutes, Your Honor.
You got it. Go ahead, sir.
Let me get my gallery set up here. It's not working. What have I done wrong? There we go. Okay. I'm getting a little long in the tooth. I'm not adept.
You're looking fine, looking fine.
New technology. May it please the court, my name is Joel Eaton. I represent Susan Sloan, who was the plaintiff below in an action against a funeral home and a funeral director. The two claims in issue were tortious interference with a dead body and reckless infliction of mental distress. The trial judge granted the defendant's motion for summary judgment. I don't need to belabor the fact that the standard of review here is de novo and that the evidence adduced below must be viewed in this court in a light most favorable to the plaintiff, with all conflicts resolved and all reasonable inferences drawn in the plaintiff's favor. Actually, although the record is long on facts, only a handful of facts are necessary for this court to reach the conclusion that this summary judgment was erroneously entered. There was in the funeral home's file an inter vivos declaration by the decedent that her cremains were to be delivered to the plaintiff after her death. That's an important fact here. The plaintiff went to the funeral home before her mother passed away, made sure that that document was in the file, and was assured that when she passed away, her cremains would be delivered to the plaintiff. Shortly after that, her mother passed away. An estranged sister and her brother showed up at the funeral home, had a discussion with the funeral director, acknowledged that the plaintiff was supposed to distribute the cremains. On their drive back to their home from the funeral home, there was a phone conversation which the estranged sister misunderstood. She called the funeral director back and demanded that the ashes be distributed to her. The funeral
What evidence is there of willfulness or wantonness on the part of the defendant?
Could you speak up just a little bit, Your Honor?
I apologize. What evidence is there of willfulness or wantonness?
Okay,
Willful, wanton.
that's the next thing on my list.
Okay, good.
Before we get to that, and I'm not to jump on ahead of Judge Atkinson's question,
No
because I want the
worries.
answer to that one too, but on the day that Ms. Hughes met with the funeral director, Ms. Sloan told the funeral director that Ms. Hughes would handle everything and declined to attend the meeting where Ms. Hughes presented the second will that revoked everything that was on file. And if you could address that and then tell it, and I know the next thing on your list is willful and wanton, I'd like to hear that answer.
Okay, let me address Judge Atkinson's question first, and then I'll return to this notion that the second will is somehow relevant to the issue before the court, because it's not. The funeral director decided, since he was getting conflicting impressions from the two sisters as to how the cremains were to be distributed. He was going to split them in half and send half the cremains to each of the sisters.
Well, I don't think it was a Solomonic decision. I think that's what he thought he was being told to do.
What he was told to do was governed by a statute. The funeral director conceded that he knew of the existence of the directive of the decedent. He was aware of the statute that gave the decedent's directive first priority, and he deliberately, intentionally, and that is the answer to your question, willfully decided to ignore the statute, which required that the remains be given to Ms. Sloan. That he decided to ignore the directive of the decedent as to how she wished her ashes to be distributed, and distributed the ashes in a way that was illegal under the statute. That's willful, that's deliberate, it's intentional. And I don't believe there can be any dispute about that on a motion for summary judgment. If
What's the
that's
defendant's explanation for why he did it?
his explanation for doing it, which plaintiff's counsel described as nonsensical below, was that he believed that an inter vivos directive directing distribution of the remains died when the declarant died. Try selling that to a jury. The
Well,
answer
he was presented though with the second will, and that appointed Ms. Hughes as the personal representative, which
let me
let me finish. By the statutory text is somebody that is the person that can issue the directive. And so that to have that be willful and wanton seems a little bit like a bridge too far, where the operative event is not what's on file, but what happens when they're making the arrangements, and he's presented with what otherwise appears to be a legitimate instrument, appointing Ms. Hughes as the PR, and under the statute, she's entitled to make those directives. And Ms. Sloan said, I'm not going to be there, let her handle everything.
I'm having a little trouble hearing you too, Your Honor, but if you want me to talk about the second will, which is one of the things that Mr. Craig is going to talk about, here's what happened and here's the chronology. The first will appointed Ms. Sloan, the plaintiff, as personal representative and directed that the cremains be delivered to the personal representative. Then the decedent executed this inter vivos declaration requiring that her cremains be delivered to the plaintiff. Then there was a second will, and it's unsure whether Mr. Magadino ever saw it. Counsel certainly made a big deal of it. The second will appointed the estranged sister as personal representative, but contained no provision concerning disposition of the cremains. So the second will did not retract or abolish, rescind the decedent's inter vivos declaration. The only document that, I'm sorry.
I think that the second will appointed a personal representative who showed up and gave, I'm not sure, and I don't want to use the word directive, but directed the defendant on how to distribute the cremains.
The personal representative's priority under the statute is below the priority given by the statute, which is first priority to the inter vivos declaration of the decedent. That's the only important document here, because the second will, although it changed to personal representative, said nothing about distribution of the remains.
Didn't the second will revoke the first will and the directive that was in it?
The second will revoked the first will. That's true. but it says nothing about distribution of the remains, and it
And
says.
the directive that was on file cites the first will as sort of its organic basis. So that will's gone, and it's difficult to understand how the directive survives, particularly when Ms. Hughes shows up with Ms. Sloan's acquiescence and says, I'm the PR and this is what I want done. And Ms. Sloan had told Mr. Magadino that Ms. Hughes would be taking care of that.
The second will does not address the inter vivos declaration, and it does not contain any provision concerning distribution of the cremains. The only document in the record is this inter vivos declaration. And the problem here, although all of this may have confused the funeral director, he was aware of this declaration. He was aware of the statute. He ignored both and chose to do what he thought would resolve this intra-family dispute. And it was willfully done. There can't be any question about that.
Mr. Eaton, you focused a good amount on the willfulness, and at least I understand your argument and what you're basing it on. I've got a question about the wantonness aspect, which is, in reading through the cases that you've marshaled about the improper disposition or exhibition of a loved one, it seems like most of those cases, and maybe this pertains more to counts 2 and 3 of your complaint, most of those cases were ones that when you read them really do shock the conscience. I mean, the funeral home puts out the wrong body. Have you located any case, and I do not mean this in any way as disrespect to the deceased, but have you found any case that addresses whether disposition of ashes between two family members, two siblings, is wanton when it even accepting your argument that it is in violation of the decedent's wish that only one of their children have the ashes? Because it doesn't immediately strike me with the same level of approbation as maybe some of the cases that you cited does. Can you bridge that gap for me, sir?
My position was simple, that this court's decision in Millette versus Trinity Memorial Cemetery 8 years ago, in an opinion written by Judge Northcutt, which is extensive and exhaustive, is legally indistinguishable from the instant case. In Millette, a summary judgment was granted in favor of the defendant. It was reversed by this court, and the facts were that the statute provided that the disposition of a deceased person's body priority belonged to the spouse, the widow, and not to the parents. The parents called the funeral home, got the funeral home to dig up the body, and
yeah, they actually disinterred a body in that case. You would agree that is just categorically different, perhaps, or maybe you would disagree, than what we have here.
That's why we have juries in this state.
Okay.
What may trouble me and what may trouble you are two different things, but in our system.
But wait, you said that this is why we have juries, but the case law that you rely on and the case law that it's based on does authorize the trial judge to make, as a matter of law, the preliminary determination as to whether the defendant's conduct rises to the level of outrageous. And in Millette, it's not hard to understand why, on review of a summary judgment with the disinterment of this body, and there were some other more egregious facts in that case, why on summary judgment review it would be put back to the trial court to send to a jury. Whereas here, given the differences in the facts, why couldn't this trial judge decide as a matter of law that this doesn't rise to the level of outrage? And there's a test outlined in these cases, is the reaction
I think
outrage?
you're correct that the initial determination is a question of law. But Millett is not legally distinguishable from this case for this reason. The court reversed the summary judgment because the statute did not give the parent priority over disposition of the body. So what the funeral home did was illegal, in violation of the statute. It ignored the superior priority of the spouse. And if you're concerned that there's a difference between disinterment of a body and distribution of cremains, I'll refer you back to a case I handled many years ago, longer than I care to remember, Smith versus Telephase Commission Society. This court affirmed a jury verdict in a case where the crematorium gave the plaintiff the wrong person's ashes.
Which
And then
is different
Yeah.
than Solomonically or not, dividing, there's no dispute that these were the decedent's ashes. And that was the funeral home. Here, the real problem is that Ms. Sloan and Ms. Hughes disagree about what to do with these ashes, and the funeral director is caught in the middle. Isn't that the case?
There can be no question what the ashes should have gone to the plaintiff in this case. That's what the mother wanted. It's in
Except
writing.
that the mother revoked the will and put the Hughes in the position of personal representative, and Sloan said Hughes can take care of everything.
We're entitled to the reasonable inferences here. Based on this chronology, first will said personal representative gets the remains. Then comes the declaration, the inter vivos declaration, that Ms. Sloan gets the remains. Then comes the second will, which
So let me ask you, I'm going to jump. Because your time, I don't want to use up all your time. I'm going to ask your opponent, the same question. And it is this: the summary judgment standard is changing in a week? And we're going to send this back. And the first thing that the defendant it would be without prejudice for the defendant to do this, is going to move for summary judgment under the new standard. How does that change, or does it change? And then, like I said, I want to hear the answer from you, and I'm going to ask your opponent the same question. Tell us why we're not just engaging in a futile effort.
It doesn't change a thing, this new Supreme Court decision, because in this case, the plaintiff came forward with all the evidence necessary to show a prima facie case. The burden may have shifted from the defendant conclusively demonstrating entitlement to summary judgment, that there's no issue of material fact, to the plaintiff to come forward with all this evidence. But the plaintiff came forward with all the evidence in this case, and it's the plaintiff's evidence that I've relied on in attempting to convince this court that the Millett decision, in combination with Smith versus Telephase, requires a reversal of this summary judgment. Now, there are two issues here.
Mr. Eaton, you're eating into your rebuttal time. You can address those two issues if you want, but I just need to advise you that you're into your rebuttal time now.
Okay, I'll rely on the initial brief on the second issue and appeal, the denial of the leave to add a claim for punitive damages.
Okay.
Thank you.
Well, I'll give you 4 minutes in rebuttal when we get back to you. Mr. Craig.
May it please the court, I am Ted Craig with Gray Robinson on behalf of the appellee, SCI Funeral Services.
Well, walk us through why shouldn't a jury get to, if we accept Mr. Eaton's premise that that there was something improper or illegal, untoward in the manner in which this deceased body was, remains were disposed of pursuant to the inter vivos trust, pursuant to, and in light of the funeral director's, so some damaging testimony. Honestly, it could be a jury could be incensed by some of the things that were conveyed there. Why shouldn't that be enough on? And you may have to divvy these up on the claims of intentional infliction of emotional distress, as well as the tortious interference with the dead body.
Well, according to the Florida Supreme Court in the Gonzalez decision, under either measure, there has to be evidence of either willful or wanton misconduct.
Mm-hmm.
And the standard for those is very high, as the court mentioned during my opponent's argument. Willful means intentionally, knowingly, and purposely with an intent to harm. Wanton means with a conscious and intentional indifference to the consequences and with knowledge that damage is likely to be done to the plaintiff. So the magical part of this is there must be knowing conduct. Plaintiff had to provide evidence below that Mr. Magadino knew that acting on the directive of Ms. Hughes, the PR, would cause harm to Ms. Sloan. And there is no evidence below.
Well, I'll take up Mr. Eaton's flag because it's just an obvious rejoinder, which is he had an inter vivos directive in his hand, and his notion of how those work was, arguably mistaken. Why is that not knowledge, right? Here's my inter vivos direction. I want everything to go to this daughter and only this daughter. Why isn't that knowledge?
Well, for the reasons that are articulated in the fact section, and it's undisputed, he received a second set of documents from Ms. Hughes indicating that she was now the PR, and the understanding was that Ms. Sloan was no longer the PR. The first will and testament, by the way, we're using this term inter vivos directive. That's a will, all right? What the statute meant to talk about was a valid inter vivo directive. And what plaintiff and the appellant wants this court to believe and accept is that a document that is not a last will and testament somehow trumps a last will and testament. We have a first will and testament. We have the document on serenity letterhead that Ms. Frisch dashed off and handed to someone at the location, which, as Judge LaBritte pointed out correctly, references the first will as the source of the inter vivos instruction. I do not treat these as separate inter vivos directives. It is a reference to her first will and testament. The second will and testament revokes everything, directs that Ms. Hughes will be the PR, leaving the question of the final disposition to, I would argue, the personal representative, or at least the family as a group. And when you look at the Millett case, the facts don't even compare. In Millett, the cemetery had actual knowledge, one, that there was a dispute between the family members. Two, the cemetery acknowledged its understanding of Florida law, dealing with a different statute, its understanding of Florida law that a disinterment could not occur without the written authorization from the plaintiff, the wife of the decedent. Third, the cemetery told the plaintiff they would not take any action without her approval and her authority. And then third, they participated in the disinterment of the remains. I don't think there's any question that the summary judgment in Millett should have been reversed. There was evidence of knowing, intentional, willful conduct. Now, when you get to the question about what the law provides, there is no question that this court in Millett did not base its opinion on a determination of who had the priority of right according to 497.005. That wasn't the basis of the holding. The basis of the holding, at least my reading, was that the cemetery acknowledged its understanding of the law and then defied its own understanding of the law. This discussion about whether the funeral home, and in this case, violated the law, to me, is a red herring, because even if the law was violated, that does not give rise to an intentional tort. The question in Millett and the question here is, did someone knowingly violate the law? And that would be evidence, again, of intentional, wanton, or willful conduct. Here, what plaintiff asks you to do is judge the credibility of Mr. Magaddino's understanding of the law, a layperson's understanding of the law. And the record does not reflect Mr. Magaddino testifying that he believed the priority weighed in the favor of Miss Sloan. To the contrary, when asked about that statute, he said, I don't know anything about that statute. And then he gave 3 times during his deposition his understanding of the priority. And he said, when I am faced with a personal representative, I follow the directives of the personal representative, regardless of what is in the file. That is consistent with the 4th District Court of Appeals' recent decision in Giat. And we discussed that in our answer brief. Giat makes clear that the purpose of 497.00538 is not to break the tie. It is not designed when there are disputing family members to resolve as a matter of law who has...
Hang on, Mr. Craig. There's one problem with Giat that I see for you. And it is that Giat restricts the application of its holding, as I read the case, to disputes between private parties. Not, because it's an injunction. You know, they're stopping one sibling, one family member from going through with a planned funeral arrangement. And if I read Giat correctly, and I've been wrong before, and I can be that way again, the holding is expressly limited to these disputes between private parties, not to be applied in the setting that we have here, which is, family member against funeral home. I mean, Giat might be more helpful if you were representing Ms. Hughes, but that's the. I don't disagree with you about what Giat says regarding the priority in the statute. I just don't know that it has any application here. And if you could address that, please.
Sure. Well, my suggestion is that the application of Giat is a correct interpretation of the statute. When you look at 497.00543, I misspoke earlier, it's subsection 43, that does not even portend to describe what you do in a conflict between family members. What 497.00543 does is simply provide a definition for legally authorized person. And what the court says, and I agree with the interpretation, is that then when there are different sections of the statute that use the phrase legally authorized person, we look to that section. Here, the phrase that would be relevant is 497.6071, which provides a cremation may not be performed until a legally authorized person gives written authorization. A legally authorized person gave authorization here for the cremation and the directive. And what Giat says is, we're looking at this statute for purposes of who can do business with a funeral home. This statute does not and cannot impose on a funeral home a duty to police the actual wishes of family members in their heart of hearts and to glean them and enforce them. What's missing in this case, which separates this case from Millett by leaps and bounds, is a lack of knowledge of a family dispute. It is absolutely a mischaracterization of the record to say that Mr. Magaddino made a Solomonic decision. A Solomonic decision would hinge on an understanding that there were competing interests. And as Judge LaBritte, you pointed out, there was never any information communicated to Mr. Magaddino that Ms. Hughes, it's undisputed, the legally authorized PR, was doing something contrary to the wishes of her sister. To the contrary, Ms. Sloan advised Mr. Magaddino that he was to follow the directives of his sister. And I think Giat's important because if Ms. Sloan had raised her hand and said, I disagree with that, and Mr. Magaddino had gone forward, you're right, Your Honor, that would be a situation where the funeral home would be defending itself against these family members. But that's not the situation. She never raised her hand. She never said, I disagree. Mr. Magaddino was completely in the dark. he found himself unknowingly in the middle of a family dispute. Ms. Sloan was invited to come. Mr. Magaddino invited her participation. He did not disregard or discredit her involvement in any way. This is a case where estranged family members allowed a funeral director to be put in a position of ignorance. And importantly, he did not make the decision. As counsel represented to you all at the beginning of this argument, he received a phone call. He was told to divide the cremains. At no time did he have any information that there was a dispute between Ms. Sloan and Ms. Hughes. And to answer the question that you posited about, will this all change on May 1st in accordance with the new interpretation of Florida summary judgment standard? The answer is we don't need to rely on that in order to have this summary judgment affirmed, because there are no issues of fact material to the issue. And as Your Honor, Judge LaBerge, you pointed out, under the Matsumoto decision, under a host of decisions, whether conduct is wanton or willful is an issue of law to be decided by the trial court in the first instance. So there are no issues of fact for a jury to resolve here. There is no evidence that Mr. Magaddino was aware of a dispute. There's no evidence conflicting with his testimony regarding his understanding of Florida law. Therefore, there's no evidence of him knowingly disregarding the law or knowingly acting in a manner that was likely to lead to any harm to Ms. Sloan.
Let me ask you, this is sort of a tangential fact, but my understanding of the record evidence is that Serenity's business practice is the funeral director doesn't review the file before the client has passed away. That the first time the director is going to pay attention to what the instructions are is at the time of need. So I'm just asking that question. Is there a dispute about that with regard to Serenity's practice, or is that an established fact? And Mr. Eaton may want to correct you on rebuttal, but.
No, the record evidence, and according to Mr. Magaddino, and he was the only witness asked about this, is that when someone presents, and what they call it in the industry is at need, at the time of need, that is when the file is pulled and the documentation is reviewed. And it is undisputed that Mr. Magaddino was presented with documentation during that initial arrangement conference with Ms. Hughes, showing that she had been made the personal representative of the estate. And Mr. Magaddino's testimony was, at that point, he follows the directive of the personal representative, regardless of whether that is
And that was the meeting that Mr. Magaddino invited Ms. Sloan to attend, and she said, no, my sister will take care of everything.
Correct. So based on the fact that there are no issues of material fact in the record, based on that this is an issue of law, whether there is an outrageous, wanton, and willful conduct, we ask that this court affirm the summary judgment. Again, this case has nothing in line with Millett, and the appellant has put all of its eggs in the Millett basket. That is the argument made in the brief, and Millett is easily distinguishable, leading to what we believe an obvious affirmance of the summary judgment.
Mr. Eaton, you have 4 minutes, sir.
Okay, you all have had a long day. I'll try to do it in 3.
Don't worry about us. We're all right.
Mr. Craig says that this document is nothing but a will, and a personal representative ought to have control of the situation. The statute makes an authorized, sets out a list of priorities, and the very first priority is this document, the inter vivos declaration of the decedent. You can't ignore it. It's in the statute. And I would submit that the reason for this statute is to prevent funeral directors from doing precisely what was done in this case. The funeral director is not in a position to decide how to resolve an intra-family dispute. he can tell the family, look, my hands are bound. You guys can argue like they did in Giat as private parties in a court over who gets the remains, but I am bound by the law. And the law says I got to honor this inter vivos declaration. If you're going to hold, as the trial court apparently did, that the law could be ignored by a funeral director in order to resolve what he perceived to be a dispute between two sisters estranged from each other and ignore the decedent's wishes as a result, then the statute is meaningless. I would respectfully submit that the statute means what is said. I continue to believe that Mr. Magaddino's belief that he did nothing wrong is irrelevant on a motion for summary judgment. He can argue that till the cows come home to a jury, but it has nothing to do with this court's obligation to construe the evidence in a light most favorable to the plaintiff and disregard everything that conflicts with that prima facie case. As Judge Leverett said, Giat has absolutely nothing to do with this case. It's perfectly clear from Giat that that was an action between two private parties, not against a funeral home and a funeral director. The case in the Millett decision involved a suit against a funeral home. And Millett is authority for the lawsuit that we have brought here, not Giat. And it is simply untrue that the plaintiff never made her wishes known to Mr. Magaddino. She went to the funeral home before her mother ever died to verify that she was going to receive the remains as her mother wished. And she had a conversation with Mr. Magaddino in which all of that was repeated before he split the ashes in half. Now, whether reasonable people can agree that this conduct violation of the statute was outrageous, I don't think that's a close question here. This case belongs to a jury. We have proven a prima facie case on the record. Millett is legally indistinguishable. Smith makes it certain here that the distribution of remains are every bit as important a basis for this lawsuit as the disinterment of a body. And for that reason, I'll let y'all go home and enjoy your afternoon. Thank you very much.
Thank you, Mr. Eaton. Thank you, Mr. Craig. That is our last case. We are actually going to go deliberate